Hello everyone, it's Wayne Jones, the course coordinator for Statutory Interpretation. Can I make some comments please regarding Chapter 5 in the textbook, Statutory Interpretation by Sanson. Interesting where we've travelled over so far, of course. We looked at Chapter 1, where I guess the take-home message was that there's so much more legislation being created these days that the task of statutory interpretation is quite important. Then into Chapter 2, where we talked about making legislation, how it happens, what are the procedures, and I guess the big take-home from there was to start to get an understanding about some of the extrinsic material that you'll look back at later when you're trying to work out the meaning of legislation. I'm thinking particularly about things like the reading speeches from the minister who's introduced the legislation, and of course explanatory memos. There are also references to things like drafting conventions and how acts are set out in that second chapter. Third chapter, still very general. We're talking, though, about interpretation legislation. The message from that chapter was that every state has its own interpretation legislation, and over the top of the lot comes the Commonwealth, also with interpretation legislation, which relates to Commonwealth laws. Remember that important point, that the states apply to state legislation, the Commonwealth to Commonwealth legislation. It doesn't matter about where you are geographically. This interpretation legislation applies to legislation from the same place. The first part of that Chapter 3 dealt with some of the common conventions around the meaning of words like number and distance and time and the effluxion of time. And I mentioned to you that it would be very important that you did have a look at section 36(1) in the Commonwealth Act, for example, which made it plain when time limits were going to run out. And I think as lawyers you really need to have a really good grip on that as well. Remember, I also said to you that these conventions can be used in drafting of commercial documents as well, although they're not going to be, your commercial documents aren't going to be bound by the legislation. They're still a really good starting point for you to think about definitional clauses in your documents. And we finished that Chapter 3 with a discussion around may and shall, which is going to keep coming up from time to time. Of course, there was also reference in Chapter 3 to when acts are amended, what happens then, when acts are repealed, what happens, something you'll need to get a grip of. Last week was context and purpose. And I think the couple of take-homes for me around context were the flow of judicial opinion seems to be now that you can almost always refer to context. It's the degree, it's the meaning of context that's still a little bit contested. So you've got judges saying, well, it can be as big as the whole history of the Act, what's been happening in the courts around the interpretation of the Act, explanatory memorandum, and other legislation. And then you'll have other more purist judges who'll say, well, no, context is okay, but really it just means the language. I think the weight of opinion has moved on from the original view, which was just the immediate context, that is the words in the Act itself and immediately around the section. But yeah, be aware that context, for the moment at least, is much broader than I think that the textbook authors refer to that in their work. So then the second part, the purpose part, was quite interesting. And you saw a few interesting cases around that. But again, the take-home around purpose is that in the previous chapter, you were told by the legislature that judges, courts, need to take note of the object and the purpose of the legislation. And so the second part of Chapter 4 dealt with trying to determine what the purpose might be, and made a number of comments in that respect, so get your head around that one. This week, Chapter 5, though, coming to Chapter 5, we start to get into some practical examples of how the judges do tend to look for, find intention, and then some of the interpretive techniques that they will use. And of course, some interesting cases as usual to illustrate. And I want to make that point first of all with respect to Chapter 5. It looks a little bit messy. There's examples of different versions of interpretive technique that the textbook authors talk about: reading down, strained interpretation, reading in, the fact that it's generally accepted that legislation is meant to have an ambulatory or dynamic interpretation. That is, it changes according to what changes according to the world around it. And then the chapter finishes with a discussion around the divide between formalism, people who are very much sticklers for the black letter, and dynamism, that is, judges who try to interpret in accordance with principles. But before we get to that, the first comment in Chapter 5 related to intention. So where does intention fit in? Well, remember when we talked about object and purpose, that was the why, what are we doing this for, and who's involved, and then the how we're going to do it. Well, that was the intention. So when we talk about intention, it's the mechanics, if you like, of how the section's meant to operate. So what's intended to be done to meet the purpose, and how's it going to happen? So giving effect to intention furthers the achievement of the purpose, because that was how the legislature intended the thing to operate. Interesting comments about the intention of Parliament. Note those. And if I took you straight away to the analogy that the textbook authors talk about, and that is in the world of business, people who look at a lease or a contract document are entitled to look at it objectively. They don't need to double guess what it was that was in the mind of the original drafter of a contract. Now think about that. That couldn't really work, could it? If I said to you, well, look, it may say that in black and white in our contract that we have between us, but I had in mind something else, well, that means that commerce is going to find it really difficult to have any certainty. And so using that analogy, you can see that the textbook authors tell you that in statutory interpretation, the same rules apply. So while judges are trying to work out what was the intention of Parliament, they don't mean that particular Parliament. If, say, you're looking at a piece of legislation from 1975, you don't have to look at the personalities. Who was the Prime Minister? What sort of a government was it? Was it Labor, Liberal, or something else? None of that applies. When they talk about intention of Parliament, it's an objective test, the same as I just described for contracts and leases and other commercial documents. An objective test, definitely not subjective. You look at the intention of a particular piece of legislation by looking at the words. So why? Well, because it would be unreasonable to suggest that parties need to sort of interrogate the background of the document with that much detail. Okay, the next thing is how do you work out what the intention is? Because sometimes parliaments perhaps don't even turn their mind to a particular outcome because it hadn't been thought of at that stage. And the good case examples that were given were Jaeger against the Crown, which was the cannabis case, and Maxwell and Murphy. Two different approaches to the same thing, though. So in Jaeger, and I would ask you to familiarise yourself with the case, when the law was passed, Parliament, as did everybody, thought there was just one species of cannabis sativa, and so the Act was passed on that basis. So the point is not so much about whether the law was correctly put together or not. The point in Chapter 5, the authors are saying to you, the drafters of the legislation could not have formed any intention about which type of cannabis they were wanting to prohibit, because that was the state of knowledge. They couldn't have known that. They didn't know at the time that there were other species. So they misdescribed it as a genus, which is the higher up in the hierarchy, the genus, whereas in fact the genus is cannabis, and the species is cannabis sativa, and then there were various other types. So Parliament could not have turned its mind to it and that was the task that the judges had to work through. Okay, well, they hadn't turned their mind to it. What does the legislation mean? And look, the outcome, just for interest's sake, was that they said, well, we think that they were referring to a genus and that all types of cannabis was their intention to prohibit. Maxwell and Murphy, well, in this one it was more just an inadvertence. So this is the case, remember, where there was a time limit, it had expired, the legislature must have considered that the time limit was too short, and after the after the claimant was extinguished, the legislature passed an amendment that simply changed 1 year, so the time limit being 1 year, to 6 years, and but didn't put any machinery provisions in to say, well, okay, if you've got a claim that's expired, this is what's going to happen. If you've got a claim that just happened in the last 12 months, this is what's going to happen. And as is usually the case with interpretation, now the 6-year rule will apply from today. Because remember, we looked at that earlier in about chapter 3, I think it was, where we talked about what happens when laws are amended or even repealed. So the usual rule would be, okay, the 6-year time limit is going to apply from here forward. But what they didn't do was they didn't say what was supposed to happen to anything that was on foot or claims that could have potentially been made yesterday. Let's say the yesterday claims, for example, that they get the benefit of the 6 years or not. Parliament didn't make any allowance for any transitional provisions. Now the judges looked at it slightly differently in that case, and they said, well, they really didn't turn their mind to it at all. It's not like we can plug a gap here. They just were completely silent on it. All they've done is change the time limits. So we're going to have to assume that in the absence of them being quite specific, claims which had already expired are going to continue to be expired. They just wouldn't introduce, if you like, that element of retrospectivity where we say, oh, look, how about we let you in under the wire? So I thought that was quite interesting. I'll just ask you to have a look at the native title claims. I won't necessarily refer to them in any details here, but essentially those claims are in that same category of there couldn't have really been any intention formed at the time, because here were cases where something had happened under legislation from the 1940s when native title hadn't even been heard of, and now many years later claimants were saying, oh well, the intention was to not interfere with native title laws, and so there was this to and fro in the High Court about whether or not you had to show some sort of intention about what your view was about native title when it didn't even exist. So sort of interesting, but it's the same point. Now, I'll just quickly mention again that Chapter 5 deals with various techniques that the judges use. Can I start by saying, don't be overly concerned about these. In fact, if you do what I usually say, and that is have a look at the rules in the back of the textbook for Chapter 5, you'll see that there's only a handful extracted for Chapter 5. So you don't need to get these down pat, because there's not always a very clear rhyme or reason as to why judges chose, for example, to read down or strain or read in or expand. Just take away from Chapter 5 the concept that judges do just that. They will expand or contract or read in or read down words into a piece of legislation. So that's the first thing to take away. And then the second is just make a note of a couple of the cases where it's been done. Put that into your collection of cases around in this area, and you'll use those to form arguments down the track. The big takeaway is that it is entirely possible for you to make those sorts of arguments. To say, look, Your Honour, there's plenty of precedent for reading down a bit of legislation so it doesn't have an unintended result, straining the legislation, stretching the ordinary meaning a little bit, provided when you do it, it's still consistent with the statutory purpose, and reading in. I thought the rules which were mentioned with respect to reading in were interesting, but look, before we do that, make sure you have a look at the Tokyo Mart against Campbell case. That was where the words were given a meaning that's not entirely apparent on their face. They were the situation there was that the language used included the word shall, so we were measuring the weight of this seaweed, either dry or reconstituted. First thing was to note that the legislature used the word shall be determined with respect to the reconstituted mass of the food. And as we talked about in previous weeks, the court didn't pay too much heed to that. They said, oh, well, shall, that's fine, but the meaning we want to give to this, consistently with what we say the object or the purpose of the Act was to prohibit the sale of adulterated food that's going to be consumed by the purchaser. So with that in mind, they didn't really have any difficulty in saying, well, sometimes food's reconstituted, sometimes it's dry, doesn't really matter. If it's capable of being eaten in one form or the other, this Act is going to apply. And we're looking at the, in this particular case, they said, okay, well, in its dry state, it does breach the regulations. So we're going to find that that's the situation here. There were some interesting other examples, but I'll leave those for you. Make sure you do have a look at that, the bikie legislation case. It's just a matter of interest, where, again, they're looking at the ordinary meaning of the words. They wouldn't try and make the legislation work. The court said, well, we're not going to strain this too much. Try and make this law work for you when the language is so plain and so clear. Remember, that was the case where the plain and clear language just said, oh, judges don't have to give reasons for their judgment. Now, that's clearly in breach of the Constitution, and so the legislation was struck down. But you can see my point. If they were going to try and strain the interpretation a bit, they might try and add in a couple of words or what have you, but they found they were up against the fact that the words were too simple and clear. Now, coming back to reading in, 2 comments. 1, make sure you do read Parrott against the Secretary of the Department of Family and Community Services. Great little case, and really illustrative, I suppose, of what we're talking about in this Chapter 5, that judges will read down, strain, read in, give a slightly different interpretation to legislation if they feel that they need to do so to make sure that the object or the purpose of the Act is being met. There's a suggestion that there should be 3 preconditions. No argument with that. So the courts, to really start to give a different meaning to the legislation other than what's there in black and white, will say, what was the mischief the statute was dealing with? The court has to accept your argument that this is just a pure inadvertence, that Parliament left some words out. And they left it out in circumstances where if it's not dealt with, then the object or the purpose of the legislation can't be achieved. And the court is fairly certain about what words they'd like to insert to overcome the problem. Now, can I make a suggestion that in relation to that last one, you wouldn't want to be trying to insert too many words. You'd be wanting to suggest a reading with one meaning over another, or maybe just a couple of additional words. But in Parrott, of course, what had happened was the legislation was clearly there to try and help farmers either overcome a current financial disaster with the drought, or secondly, exit from the business altogether with a little bit of dignity and a couple of dollars in their pocket to get sort of unproductive farmers off the land. And that was pretty clear. Also note the textbook authors referred you to the speech that was given by the minister who introduced the legislation, saying exactly that. But what they hadn't taken into account was when they talked about earning your income from farming activities, they're just trying to make sure this was just for farmers, that sometimes the circumstances would be so straitened that there wouldn't be any money, so that the farmers would make no money. And therefore, could they really be said to be deriving a significant part of their income from the farm enterprise? So what was omitted was clearly a reference to you might actually be making no money at the moment. The three preconditions could be easily met, and the court read the section in the legislation so that the farmer did receive his compensation. With respect to ambulatory or dynamic interpretation, don't make too much of it in Chapter 5 because you're going to see some better examples of it as we proceed a little further into the textbook. The language is that the statute's considered to be always speaking. It has a meaning which can change over time. They use language like the equity of the statute, triumph of substance over form, pragmatism over formalism. But essentially, the best way to describe it is with examples, and you're on safer ground when you're talking about legislation, the meaning changing slightly when you think about things like obvious terms like the use of the word vehicle in legislation in early in last century, for example. Well, that might include now all types of cars, might even include an aeroplane. And you used to see that funny word, I don't even know whether it exists much more anymore about a road being described as a carriageway. I mean, that's language that continued for a very long time. The statute always speaking, obviously a carriageway could mean now a 6-lane superhighway going somewhere. Anyway, good example of the statute always speaking, and some better ones ahead. One final case to take note of, and that's Comcare and Thompson. That was the example again of judges trying on some different interpretive techniques, and once again, as was the situation of Maxwell and Murphy, but for different reasons, the court said, well, no, we can't really help you this time. And Comcare and Thompson was where the claimant was receiving a benefit because he'd been unwell, and the legislation was working just fine. It talked about when your colleagues get pay increases for a variety of reasons, you shouldn't miss out just because you're on Comcare. And then along came a completely different system, Australian workplace agreements, which no one could have foreseen. And Thompson said, well, if I was there, I'd be part of this whole AWA system. I should get a payment. Now, I reckon from what you've heard so far that your argument on behalf of Thompson would have been, well, look, let's have a look at the object or the purpose for a start. And my suggestion to the court would be, well, look, it's just to make sure that people who would ordinarily be receiving a salary, but they're on a benefit at the moment, will continue to have that salary keep pace with what they would have been earning had they not been on the benefit. So to make sure the object therefore would be to make sure that injured workers aren't unfairly left out, and the intention would be to ensure that happens by giving them regular pay rises in accordance with those different rules. But interestingly, the court said, no, that really could never have been in the contemplation of the legislature. It's not even possible to stretch the rule a little bit and say, oh, well, the equity of the statute suggests that salary increases of every type should be allowed. They said, no, it's still got to sort of fit within what the written word says. And I think that's an important case from that perspective. So look, in that divide between formalism and dynamism, just to finish off Chapter 5, a couple of really good little rules suggested towards the end, and I think they were drawn from an article, which if you're interested, I would recommend to you. Now, just give me a sec. That article was written by Chief Justice, I think it was Chief Justice Gleeson. Apologies. Yes. And this is the extract. He said, formalist judges must take into account context and purpose. So that's the first thing. Even a judge who was very strict about formalism, I want to say what the words mean, based on the black and white language, they still have to take into account context and purpose. And dynamic principled judges, So these are the ones that are a little bit more interested in, well, what's the Act really about? What's the principle behind it? They've still got some rules that they're bound by, and they are these. That interpretation is always text-based. The task is to interpret the words of the legislature, not try and divine what its intent was. So you can't get that back to front. You're still looking at the words. Intention helps you, but you're not divining what the overall intention was. You're doing it around the words that you're looking at. You've got to determine what Parliament meant by the words used. So that's the parameters. You've got to determine by the words used, not what you think it intended it was going to say. And I guess that Parrott case is a really good example of that, as was Comcare and Thompson. Parrott, they did allow some flexibility because the words were there. There were sufficient words there to get an understanding that, look, it's just an inadvertence. But in Comcare and Thompson, there just weren't enough words there to work with. So you've got to determine what Parliament meant by the words used, not by what you think they intended they want to say. The meaning has to be reasonably open. And again, that's that Comcare and Thompson case. You couldn't read it to mean in all circumstances. There just weren't enough words. And the interpretation must be based on the intention of the Parliament, not the intention of the judge. And I guess that goes without saying. You've heard that enough times already. So look, overall with Chapter 5, can I just say this to you? They're just examples which tend to demonstrate overall that judges will put some flexibility into the words. There's still a continuum from what Justice Gleeson called the formalist judges back towards the dynamic principle judges, so it's a bit of a continuum. Don't sweat it. Look at the cases, make some notes about a couple of these interesting cases and move on to the next chapters, which will be dealing with intrinsic material and then extrinsic material. But just keep in mind that these were good examples of how judges will in fact stretch or limit the meaning of words to try and make sure that the object or the purpose is being met. I'll talk to you again soon.